Hello, good afternoon. This is Aaron Hall, immigration attorney at Joseph and Hall, and I am here to do the weekly update. As a reminder, we are doing these video updates on immigration law and policy and things in the news on Mondays at 12:30 Denver time in English and Wednesdays 12:30 Denver time in Spanish. So with that said, let's get into today's topic. So I wanted to address some rumors that I've been seeing online, and they are that LPRs, so lawful permanent residents who have their green cards, are being arrested coming back from international travel. So they go abroad, they see family, or they go on vacation, and they come back, and they're being detained by Customs and Border Enforcement, um, Customs and Border Protection, excuse me, either at the port of entry at the border or at an airport. So, as is often the case, some of these rumors come from some kernel of truth, and I wanted to address exactly what's happening, and hopefully that will allow people to assess whether they can travel with confidence if they are an LPR. So first, what's important to know is what the immigration law says. So this is the Immigration and Nationality Act. It says that the Department of Homeland Security cannot treat a person as an applicant for admission if they are a permanent resident and they're coming back. So that's the general rule. And by not allowing them to be treated as an applicant admission, what that means is that they must be allowed to return and enter the United States without undue delay, and they get to resume their lawful residence. So that's the general rule. Keep that in mind. That said, the law provides for them to be treated as an applicant for admission under 6 circumstances. So there are 6 exceptions. And it's important to know that if they are to be treated as applicants for admission, then the government has to prove one of those 6 exceptions by clear and convincing evidence. So what are the exceptions, and what does it mean if one of these exceptions applies to your case? Well, first, what does it mean? If you're treated as an applicant for admission at the port of entry, you can actually be detained. And how it usually plays out is somebody would be detained, and then the CBP officer would say, hey, you could sign this form abandoning your residency, and we'll put you on a flight back to your country of origin. Or if you want to try to fight for your residency, that's fine, but we're going to detain you, and then you'll have to take it up with an immigration judge. And the huge problem here is that where somebody's an applicant for admission at the port of entry, the immigration judge doesn't have jurisdiction to order a bond. What that means is that unless ICE decides to let them out, they will be detained while they go to immigration court hearings that can stretch on for weeks or months, or sometimes many months if there's an appeal, or up to a year. So obviously, nobody wants to be arrested, held, and made to fight for their green card in custody just coming back from international travel. So what are the circumstances where this becomes an issue, where we're worried that this could happen? Well, again, the general rule is it's not going to happen because they must be allowed to re-enter. They're not considered applicants for admission. But what are the 6 exceptions? First, where the person has been absent from the country for 180 days or more. It's actually more than 180 days. If they're gone, you take a long trip and then you're coming back, then you can be treated as an applicant for admission. Second, if you've engaged in illegal activity since departing the United States, you can be treated as an applicant for admission. Third, if you've departed the United States while under removal proceedings, and that means they've usually issued a notice to appear and filed it with a court. If that's happened, and then you leave the United States, even though you're still an LPR, you can be treated as an applicant for admission. Fourth, if you've committed certain crimes that trigger inadmissibility, and you've been convicted of those crimes. Fifth, if you have attempted to enter the United States illegally without inspection. That would be pretty rare because if you have a green card, usually you're not trying to cross the border illegally, but it could happen. And you could imagine circumstances where maybe somebody was engaged in smuggling or something like that, and then they could be treated as an applicant for admission. Or sixth, if they've abandoned their lawful permanent resident status. So the kernel of truth that I talked about is that it appears that the Department of Homeland Security and CBP are taking a much more aggressive stance towards these 6 exceptions. So, for example, if somebody has an NTA filed with a court, there's reporting out there that's credible that the American Immigration Lawyers Association has put a practice alert out about that says that they are regularly detaining people when they come back if there's a notice to appear issued in their case. And we would expect that that aggressive stance would also be taken towards people with certain criminal convictions if they're traveling. And what's tricky about it is there's lots of cases where people have a criminal conviction that might be 20 years old. They're a permanent resident. They've traveled back and forth to their country of origin many times a year for 20 years. And then all of a sudden, out of nowhere, they get popped and detained. So that is something to be wary of as well. But I think what the takeaway is that even though there is reporting that they're taking a more aggressive stance on this, it's not for everybody. So, and it's not at random. So it's not anybody with a green card that is traveling abroad and they are brought back or they come back to the United States and then they are arrested, detained. That's not happening. It's where one of these 6 exceptions applies or arguably applies. And so for that reason, I think for lawful permanent residents who are thinking about traveling abroad, they want to be confident that none of these 6 exceptions applies. For lots of people, they don't apply. For most people, they don't apply. And lawful permanent residents are traveling and coming back every day in countless numbers, even under the Trump administration. So I want people to know that general rule, and it still applies. However, if there's a complication to your case, which means one of these 6 things might apply, most commonly criminal convictions in the past or removal proceedings have been started against you, or you have an absence of over 180 days, something of that nature, then it is a really, really important thing to consult with immigration counsel before you plan your trip abroad, because you want to either have assurance that I'm in good shape, nothing can happen to me when I come back, or at least you want to be aware of what the risks are. And knowing that risk, you can make informed decisions. So that's our update for today. As I said, we'll be back on Monday, 12:30 Denver, with another update in English. The Spanish language update will be this Wednesday at 12:30 Denver time, and we will see you then. Thank you.